So thank you to everybody who's joining us. For those who don't know me, I'm Laura Skillen, the Executive Director of the International Mediation Institute. Just before I introduce our guest today, a little bit of housekeeping. For those who haven't used Zoom webinar before, you'll see that there's a Q&A section at the bottom of your screen or at the bottom of your phone. If you do have questions throughout Wolf's presentation or afterwards, please insert those questions in the Q&A so that we can answer them in an orderly fashion. Great, but with no further ado, firstly, hello to our friends at SIMI who are joining us today, of course. Thank you as well to CIR Southeast Asia, who are supporting organisation for today's event, and for members of that. And welcome to Wolf. Wolf von Kumberg is a fantastic, I think, mediator, and fantastic person to have on this call. Not only is he a former IMI board member and current ISDS task force member, he's with Inter Arbitrators and Mediators London, and is also former Assistant General Counsel at Northrop Grumman Corporation. So thank you very much for joining us, Wolf. Thank you very much, Laura, and thank you for having me. As Laura says, I'm currently a member of Inter Arbitrators and Mediators in London, and I've been an accredited mediator for approximately 20 years. Over the last 5 years, I've been involved in helping to develop the field of investor-state mediation. With the signing of the Singapore Convention in August 2019, mediation has been given new credibility as an international process for the resolution of disputes. Having been an in-house lawyer for several international companies over more than 25 years, involved in many cross-border disputes, this was, to my mind, a decisive moment. Our international contracts had usually included arbitration provisions for the resolution of disputes. I'd also tried to include mediation provisions, but particularly when dealing with states or state entities, I always found I hit a wall. They simply did not want to provide for mediation. In most cases, either because they did not understand it or felt it was a process too ill-defined for state officials to be involved with. The result was somewhat better when dealing with private companies, but even there, it very much depended on their size and sophistication, and critically, where they were located in the world. Fast forward to August 2019, and what has now changed? To understand that in the context of investor-state disputes, one must first look at what has been happening in the way of encouraging the use of mediation generally. In the past, mediation simply was not often contemplated in the context of the investor-state dispute settlement system, ISDS. It had its own unique dispute resolution system that had grown out of investment treaties negotiated between individual states, bilateral investment treaties, or also known as BITs, or on a multilateral basis between larger groups of states, such as NAFTA between the United States, Mexico, and Canada. Previously, these agreements contemplated that arbitration would be used to finally resolve disputes between investors and states. Mediation was not even mentioned or contemplated to have a role in these disputes. ICSID, the body of the World Bank responsible for trade disputes, had arbitration rules, and in addition, a set of conciliation rules. The conciliation rules were not, however, a form of mediation, but rather a tribunal that heard the dispute and then rendered a non-binding opinion. Most parties never used conciliation and moved directly to arbitration. The cooling off period provided for in BITs, usually 3 to 6 months, was not used to try to find a resolution to the dispute, but rather that time was used to prepare for the arbitration. 5 years ago, I started assisting the Energy Charter Treaty Secretariat, a grouping of 54 states, which establishes a multilateral framework for cross-border cooperation in the energy sector, to look at how mediation could be introduced to its rules.
The rules provided for arbitration to resolve disputes with investors and had a reference to conciliation without any specific process. The Secretariat was interested in filling in the gap by providing for the possibility of mediation. We worked on a mediation guide, which would provide the member states with an outline of the mediation process and how it might be used in an investor-state dispute. The guide on investment mediation was published by ECT on the 19th of July, 2016. It was recognized that the guide alone was not enough. States have largely not mediated because of the lack of an internal framework through which the mediation process could be carried out. Issues such as authority to settle, transparency versus confidentiality, responsibility, liability for taking decisions, and state budgets were all a factor. As a result, the Secretariat then went on to review with the member states a model framework that could be adopted within state structures through which these issues could be dealt with. This model instrument on the management of investment disputes was published by the ECT in December 2018 and has been adopted in the interim by several member states. In addition to the ECT, I have also been working with IMI, ICSID, and CEDR to develop IS mediation awareness programs and training for mediators in states. It was recognized that without this training, the knowledge required for states to mediate these disputes would not exist. In addition, to give the process credibility, a cadre of mediators who not only understood mediation, but also ISDS had to be trained. Since 2017, several annual IS mediator training courses have been held, and mediators capable of handling these cases are now prepared. Even more important for the acceptance of mediation in these disputes is the fact that ICSID, the organization through which most of these disputes are heard, has given its full support to the development effort. This culminated in December of 2019 with ICSID publishing its own IS mediation rules. This has given the initiative credibility with both investors, their counsel, and states, and was a strong step forward to making mediation part of the ISDS process. In fact, there have already been several important investor-state disputes where mediation has now been used. The most recent reported case, as many are not reported, was that of the Dominican Republic and Odebrecht that was mediated this January by well-known international mediator, Mrs. Mercedes Tarazon. The matter was mediated under the ICC mediation rules and led to a settlement agreement between the parties. So back to the Singapore Convention. Many aspects of the convention have been well covered in this webinar series, and I will not repeat them. Only to point out the preamble, which to my mind is of key significance to the development of investor-state mediation. And let me just read from that preamble. Recognizing the value for international trade of mediation as a method for settling commercial disputes in which the parties in dispute request a third person or persons to assist them in their attempt to settle the dispute amicably. Noting that mediation is increasingly used in international and domestic commercial practice as an alternative to litigation. Considering that the use of mediation results in significant benefits, such as reducing the instances where a dispute leads to the termination of a commercial relationship, facilitating the administration of international transactions by commercial parties, and producing savings in the administration of justice by states. convinced that the establishment of a framework for international settlement agreements resulting from mediation that is acceptable to states with different legal, social, and economic systems would contribute to the development of harmonious international economic relations. So I think that preamble is extremely powerful, and it's something worth taking another look at if you haven't done so. And I think that, in a nutshell, is the real importance of the convention to the continued growth of the use of mediation in ISDS. In short, it is a fact that states, by signing and ratifying the convention, have recognized the use of mediation as a legitimate instrument for resolving cross-border disputes. This gives mediation enormous credibility as a dispute resolution mechanism that can be used as part of the dispute resolution toolkit. Once states have acknowledged this for commercial disputes generally, it is difficult for them to take the position that it does not apply to the state itself or its agencies when dealing with investors. In fact, if we take the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards as an example, very few states have excluded the application of the convention to arbitrations involving states or their agencies. In fact, one of the reasons international arbitration became popular and an acceptable dispute resolution tool was that arbitral awards can also be enforced against states under the New York Convention. This example provides the blueprint for the enforcement of mediated settlements against states as well. It is not so much enforcement that is important, as most states, when they actually agree to a settlement, will abide by its terms. But the recognition by states through the Singapore Convention that mediation is an acceptable means of resolving disputes. Given the world financial crisis that we are currently experiencing due to COVID-19, the imperative to use mediation in an investor-state context has only grown. Arbitration as a mechanism for resolving these disputes has limitations. Some recent developments help to emphasize this further. The Columbia Center on Sustainable Investment has called for a moratorium on all arbitration claims by private corporations against governments using international investment treaties. On the 5th of May, 2020, so just a week ago, a large number of EU member states signed an agreement for the termination of intra-EU bilateral investment treaties. This implements the March 2018 European Court of Justice judgment in the ACMEA case, where the court found that investor-state arbitration clauses in intra-EU bilateral investment treaties are incompatible with the EU treaties. The interest in investor-state mediation has grown tremendously over the last few years. Last December, a group of stakeholders in the ISDS community met at Harvard to discuss the issues surrounding IS mediation and possible options to increase its use. A report coming out of this colloquium will be published shortly. A further forum on IS mediation is planned for this November to be held at BICL in London. These developments clearly do not spell the end of arbitration in investor-state disputes. They, together with the Singapore Convention, do, however, provide scope for mediation as a credible alternative. And with that, Laura, I thank you very much, and I'll turn it over to you for questions.
Perfect. Thank you so much, Wolf. That was really interesting. And so I've got a couple of questions here already. And if anyone else does have further questions, please add them to the Q&A. Otherwise, I'll start bugging Wolf with all my own questions. So we have a question here from Daniel Pakpahan. And he asks, do you think the Singapore Convention will promote more respect for cooling off periods or negotiation clauses in investment arbitration agreements?
So that's a very good question. As I suggested, the cooling off periods have generally been used by the parties to prepare for arbitration and not concentrate on trying to resolve the case through negotiation or through mediation. I think this is starting to change. The problem is that the cooling off period comes quite late in the day, and often the relationship between the investor and the state, depending on what has caused the dispute, has completely broken down. And at that point, it's the lawyers that are involved. So it's perhaps a little late to start looking at utilizing mediation. Mediation can be used much earlier on in the process. And I think that's the way both states and investors are starting to look at it. And talking to a lot of lawyers who are involved in investment estate disputes, they're also, I think, starting to look at perhaps advising parties to at least contemplate mediation earlier in the process. And that is, in fact, also what the model instrument that ECT developed encourages states to do, to start looking at trying to deal with issues that arise with investors. And that's usually where it first starts before it even becomes a dispute, trying to find ways to deal with those. Many states have now actually put in place ombudspersons that are meant to be a catalyst for issues to be brought forward by investors early on.
Great. Okay, another question, this time from Susan Frank. And she asks, given that there has been a proposal for a moratorium to eliminate the bringing of all investment treaty disputes given COVID-19, how is this likely to affect mediation and the Singapore Convention rollout at this moment in time?
Yeah, that's another very good question. It's interesting that call for the moratorium. It'll be interesting to watch that and see how much take-up there is with respect to it. It's obviously a crucial moment, and I'm seeing this generally with commercial disputes as well. Parties recognize that leaving the dispute to a later date where it can either be litigated or arbitrated might not be the best way to deal with these issues that are coming out of COVID-19, but rather some type of structured settlement negotiation or mediation makes a lot of sense, because a lot of the issues that are coming out of this, and it'll be the same with investor-state situations, are issues that might create a legal right or legal obligation on a party. But in fact, what's necessary is a restructuring of that obligation, because it simply can't be performed. Yes, you can't perform it, and so you're in breach, but what does that necessarily then mean if you want to try to find a resolution? And I think at the moment, it's much more sensible for parties, and I think there's a recognition of this, to try to restructure those obligations. And the best way to do that is through, as I say, some kind of structured negotiation or mediation.
Super. And Susan points out, she even asked this question before you mentioned it, so she gets bonus.
Yeah, well, I think it's interesting, that call for the moratorium. And in particular, because states now have to take actions dealing with COVID-19, which could very well affect investors. The call for the moratorium goes on to deal with that specific issue as well. And basically to put a ban on any type of investor state action that arises out of the states dealing with the COVID-19 issue. And one can see the attraction in that.
Yeah. A question from Ronnie Casas, and she asks, capital importing states frequently find themselves in the position of respondent in investor-state disputes. Would the Singapore Convention perhaps seem more attractive to these states than to states that are frequently the home states for investors, i.e. the global north countries? And if so, how can we overcome such a challenge?
Yeah, I think, I mean, if we're looking at, the states that are currently ratifying the Singapore Convention, it's not just the developing states, but also the Western states that I think have an interest in the convention. I think generally, and that's one of the things I try to emphasize, is that states overall have an interest. And just looking, it's interesting at the ECT and the 54 states there, that's very much state-driven. And that whole process within the ECT has been driven by states, not by investors. So it's states, and those are both developed and developing states that are members. And it's those states that thought it would be prudent to try to find an additional mechanism for resolving these disputes. So it's not that arbitration isn't going to continue to be an important element of the dispute resolution process, but rather that there be also an alternative. And I think that's the way mediation is being seen. So I think it's both developed and developing states that see an interest in this. And I think they're both going to be ratifying the convention. It's not just that one set of states is looking at this as a means of perhaps dealing with their disputes.
Absolutely. And on the topic of ratification, we've got a question here from Bart Wozniak, who asks, what is your prediction as to the pace at which states will ratify as opposed to signing the convention?
I think, well, and of course, the ratification process is often a lengthier process for states to go through, depending what's required. But I think perhaps even COVID-19 might be an impetus for states to ratify more quickly, simply because there's a recognition that there has to be another mechanism for dealing with these disputes. I think, in fact, that this will spur states on. So my prediction would be that there will be an increase in ratifications.
Great. We'd like to see that. Okay, a question here from Simon Potter, who asks, the political will to litigate or arbitrate is different from the political will to settle the litigation away. How does this play into planning for IS mediation?
Again, a good question. I think that mediation is a process which people have to agree to. It's something that's voluntary, and I think it's a process that lends itself very much to the investor-state forum, because investors are, of course, interested in seeing that their investment is successful. States are interested in having inward investment and creating a climate for that kind of investment. So I think mediation in particular provides a good mechanism for both sides.
Absolutely. And we've got a long question here from Brian Chang, and we've had to distill it down a little bit. So Brian, if we've misrepresented your question, please let me know. But he asks, in essence, how realistic is enforcement of specific performance of obligations in an international mediated settlement agreement against states if there are no relevant reservations?
Well, I think, and this is the interesting thing, of course, about mediated settlements. And that's why I think I made my comment that, it's not so much the enforcement element against states once they enter into a settlement agreement. It's difficult for states to go through that process to begin with, and that's been the issue in trying to have states mediate. But I think once the state actually puts a mechanism in place, and once it agrees to a settlement, the enforcement element isn't really the issue. So I think, you know, going forward, if states do agree to a mediated settlement, that investors will generally be able to rely on the elements of that settlement. I think it's harder sometimes when there's an arbitral award, and we see that, to actually implement the award against states. And I think that's where a mediated settlement actually can in many ways be more beneficial, because states will comply with the elements of that settlement agreement.
Super. Now, Ivana Ninchik has asked, do you have any recommendations for raising awareness on the benefits of mediation for the state and for introducing procedures or protocols which enable the use of mediation?
Yeah, so I think, you know, a good place to start is what the ECT has done with its member states, and the protocol that they've put in place, the model. And it's really worth taking a look at. And if you go to the ECT website, you'll be able to find the model instrument, because it's quite comprehensive. It doesn't just deal with mediation, but it deals with negotiation, and it also deals with implementing a process within the state to deal with disputes generally. So it's just a good roadmap for states to utilize whenever they have a dispute, because in many states, particularly states that where the administration is perhaps weaker, often they only start to deal with the dispute very late on in the process, and that then also makes it much more difficult to settle that kind of dispute for these states. And so this model, as is suggested in the question too, is something that is extremely useful. And so I would highly recommend both states and investors take a look at that.
Absolutely. And there's actually a link to that as well on the IMI website for anyone who has difficulty coming across it. Now, Dilyara Nigmatulina has asked, could you give more examples of mediation being used in the investor-state context and where information about such cases might be found?
Yeah, so there have been some, because mediation is a confidential and private process. Often we don't hear anything about these settlements. We know from ICSID statistics that a lot of ICSID cases that are filed then are withdrawn, but the reason for the withdrawal, of course, can be numerous. It doesn't necessarily mean that they've been settled, but I think generally there is a feeling that a fair number of those that are withdrawn have been settled by some mechanism, not necessarily mediation. But we know that there have been several recent cases where mediation has been used by states. And I referred to the most recent one, which has been published, and there is a reporting of it in January of this year. It was held in New York under the ICCC mediation rules. Mercedes Terrazon was the mediator, and that was between the Dominican Republic and an investor, and that was successfully settled. And I mentioned that we're going to have an IS mediation forum in London at BICL in November, and Mercedes has told me that she will come and she'll talk a little bit to the extent she can about that case. So that should be very interesting to hear from her.
I think a lot of people are looking forward to that. I know I definitely am. It sounds like a really interesting case. Now, I've got a question here from Rana Ahmad, and she asks, do you think the MEDARB mechanism could be considered more viable for settlement of investor-state disputes during the COVID-19 pandemic?
Yeah, I think the combination of the two, and they shouldn't be seen as being exclusive of each other. That's a very good point, because I think it fits in very well. I mean, even where arbitration has been commenced, mediation certainly has a role. Often in commercial cases, there will be a step disputes clause where you first have mediation and then failing that have arbitration. So you do first have to try to mediate before you arbitrate. So that's, I think, an incentive. The American Arbitration Association commercial rules actually require mediation before arbitration, and very few parties actually opt out of that. So there's a recognition that mediation can be very useful, at least to attempt, and if that fails, you then move on to arbitration. And of course, you can then mediate again, even after arbitration has been commenced.
I've got one from Swarupa Madhavan. And she asks, how would the reservation to exclude settlement agreement involving state or state-owned enterprises from the Singapore Convention affect mediation in ISDS? Do you expect more states to adopt this reservation?
Yeah, that is a good point. You question why a state would make that reservation when the state has actually ratified the convention, and that's why I wanted to emphasize the preamble to the convention, because it's just such a very powerful statement of the benefits of mediation. And so why would a state deprive investors in themselves of the benefits of that process? So that's really why I raise it. I question how many states actually will make that reservation, and I pointed to the New York Convention, because that's a good example where states might make that reservation, but overwhelmingly they have not. And so I don't see why that should be the case under the Singapore Convention.
Mm-hmm. Great. I've got a two-part question from Daniel Pakbahan, so I think we'll go at it a few times. So he says, considering the number of frivolous claims and the prevalence of abuse of process in investor-state arbitration, leading with guns there, do you think mediation can save the face of ISDS and promote investment? That's part one.
Yeah, I think, to me, and I've talked to a few states about this, I think mediation is a very good tool for them to implement in order to attract investors, because investors, particularly now, and I think under the current environment, let's see what it looks like as we come out of COVID-19. Clearly, there will be a lot of reluctance for investors to go into, certainly into developing states, perhaps, because of other issues, let alone having a dispute resolution mechanism that is acceptable. So I think it'll be even more important for states to have things like ombudspersons and mediation as part of their overall resolution system for investors to feel more comfortable. So it's actually a way to draw in investors, and so I think yes, I mean that is certainly what states that I've seen anyway. States are interested in utilizing mediation in that way.
Mm-hmm. Well, I think you've already partly answered the second part of this question, but I'll ask anyway in case there's anything I've missed. So we asked, would states renegotiate BITS and include mediation as a condition precedent to arbitration, or maybe the primary or sole method of dispute resolution? And how do you recommend states deal with frivolous claims? Would it be preferable to settle through mediation just to save time and effort, or should they try to fight and seek for a win in arbitration and establish jurisprudence?
Yeah, well, again, that's a good question. I mean, I think a lot of different factors that will go into the decision that a state makes in that situation. As I said, investment climate is clearly a priority for states, and if they're seen to constantly be battling with investors in arbitrations, that doesn't send a good message to investors. At the same time, of course, states don't want to be taken advantage of, certainly by frivolous claims that are being made simply because the investor feels the state will settle that and then they'll get something out of it. So obviously the state has to consider both ends of it. I think that, I mean, the attraction with mediation, and this is one of the questions, of course, that's being debated, is, to what extent does mediation have to be transparent in these types of disputes? As we know, in commercial matters, mediation is actually a confidential process. So the parties don't actually divulge, even in many cases, that the mediation is taking place, let alone what the settlement results were. However, in an investor-state situation, the state, of course, has responsibilities to its citizens, and in the vast majority of those cases, the state will at least want to say something about the negotiation that's taking place, also simply to make the process more trustworthy in the eyes of the citizens. So it's something that I think has to be balanced. And so again, I think that there are a lot of attractions for states to mediate all of these disputes, if at all possible. But there will be clearly situations where the state will have to be more robust and will take it to arbitration to send a certain signal that they might want to send. Of course, there's no guarantee that they'll be successful in the arbitration. I mean, it's interesting, under the ICSID statistics anyway, show that states are actually much more successful than investors at the end of a lot of these disputes. But by the same token, there's a huge cost, and particularly the unknown factor. If the state loses the case, all of a sudden its budget is going to be hit with a large amount that might not have been contemplated.
Mm-hmm. I've got Simon Potter with another question, and he asks, sometimes arbitral awards are high enough that the host state has trouble paying and the investor has to think of enforcement around the world. Is there room for mediation as to how, post-award, the award can be satisfied over time or in part or in kind?
Yeah, that's a great point as well. And that, often happens in commercial litigation as well, where the mediation takes place at the appeal stage, because while the parties might recognize that there's been a judgment or an award against them, they simply can't satisfy that judgment or award. And so there has to be some type of a structured negotiation, and mediation is a good forum for that, in which then the actual award is negotiated. So it may be that it can't be paid immediately. It might have to be paid over a period of time. Perhaps there is the forgiveness of part of it, and the sum is reduced. But it's a great suggestion, because states don't want to be seen as defaulting on these awards, and that's a good face-saving mechanism for states to utilize. So mediation should be considered in that context as well.
Mm-hmm. Super. Now, Susan Frank asks, you've mentioned that mediation and ombudsman can be used effectively early to manage the investment treaty conflict. There are practitioners and scholars such as Roberto Acandi and Mariana Hernandez Crespo who are looking to help roll out early conflict management mechanisms to promote investment and prevent money and resources being lost on formal adjudication. How can the Singapore Convention be used to help those strategies and dispute systems design initiatives?
Well, again, I think the Singapore Convention is a good demonstration that states understand and support mediation as a process. So it gives mediation legitimacy. If we look again at perhaps the model instrument and utilizing something like that within the framework of the state, so that issues that arise are dealt with before they even become disputes, then I think a combination of the Singapore Convention and the message it sends, together with the implementation of some type of framework within the state to deal with disputes, that can then lend itself to early resolution. Clearly, early resolution is of benefit to everyone, because if it's an investment that the state is interested in continuing, finding a way to have the investor stay is obviously of advantage to both the investor and the state. So an early resolution mechanism is clearly something that's desirable.
Definitely. And not to give any spoilers, but IMI might be working on something along these lines quite soon. Now, I've got another question from Daniel Pakbahan, which I think actually ties back to what Dilyara was asking earlier, because he asks, are there any talks on formulating a rules and transparency for investor-state mediation, such as the UNCITRAL rules of transparency for arbitration? And he gives a further suggestion that there might be soft laws or guidelines on domestic civil or commercial mediation that could be useful and applicable in this kind of situation.
That's a great point, and it is something that is being discussed, and it was something that was discussed at the Harvard colloquium in December. And as I said, the report coming out of that colloquium should be published very shortly. I think one of the reasons to have a further forum in London in November is for that discussion to continue. And I think that whole area of transparency and how that might be tackled, in a mediation context is going to be an important subject for discussion. And yes, I mean, we certainly can take guidance from domestic situations as well, where, it's interesting to see, partially it's, I think, also cultural in some countries. There's more credence given to confidentiality and less so in other countries. I mean, it's very much, I think, also a cultural thing. And so it has to be addressed in some fashion for mediation in investor-state situations as well.
Mm-hmm. And this actually ties to a question that I had, so I'm going to be very cheeky and throw it in there. Mm-hmm. I mean, what, if any, kinds of expertise do we still need, do you think, in order to promote or grow this area of dispute resolution? I mean, what would help? You've mentioned the Harvard colloquium already. What do you think we need still?
Well, I think it's like with mediation generally. I mean, you see that. I think it's still awareness. I mean, it's building awareness and understanding for the process and how the process can be utilized. I mean, mediation is an extremely flexible process, and it can be adapted in many different ways. I think for states in particular, and I've seen that just with the ECT process, it's a matter of educating them, having them understand what it is, first of all, and then how it can be utilized in that particular state for the benefit of the state and investors. So I think it's just getting out there, growing the awareness, ensuring that the proper framework is in place for it to take place through, and the Singapore Convention. I think the Singapore Convention is really a game changer for this, simply because states then recognize that mediation is a key element to resolving these types of disputes.
And so then if there was an ideal target or advocate in state, so say for example, you have a magic wand and you can instantly turn this particular person in all the states in the world into advocates for mediation, who would be the most useful person, do you think?
I think it really depends on how that state is structured and how it's organized. I mean, each state has its own particular structure, a power structure, and people who are influential within it. So I think it's difficult to say there's one particular point, and that's one of the interesting things that was debated at the ECT too. Is how do you deal with this? I mean, is it one person like the Prime Minister's office that is responsible for this? Or is it actually a larger group? And I think the understanding is, typically it's a larger group, although it might be the Prime Minister that's designated or the President in some cases. Rather, it's often it's a committee of various cabinet members that make the decision as to what is to occur, whether it's a negotiation or a mediated settlement. And I think you have to have that kind of flexibility. I mean, just talking to some states, sometimes it's a particular minister, sometimes it is the Prime Minister. I think it's different organs. I mean, one is obviously the group that's interested in attracting the investors. So, it's that ministry that is key, but it's also often then the Justice Ministry, because they're involved in the actual disputes when they occur. And so I think it has to be a combination of different organs within the state that are involved.
No, I think that's really valuable, because I mean, we do have a lot of questions in these webinars that sort of arise over, well, how can we get this ratified, or how can we get this done, or how can we change people's minds in our own states? And it sounds like the message is, well, for each country, each place is going to be different. You need to identify the stakeholders before you can actually make effective interventions.
Yes, exactly.
Yeah. So we've got another question from Susan Frank, who asks, how can we change, this is a very popular question actually, how can we change the incentives of counsel advising clients who may not have the same economic incentives or knowledge base, let alone comfort level, with encouraging clients to conduct mediations?
Mm-hmm. Again, it's a real challenge, and it's interesting, that question, because I remember it must have been 5 or 6 years ago, I was addressing an ICC conference in Montreal, Canada, and I was talking about the potential of using mediation in investor-state disputes, and the lawyers there almost overwhelmingly told me this is never going to work in the investor-state context, because states simply won't mediate. I looked at it a little bit cynically, I guess, thinking, well, yeah, because all of you in the room actually make a lot of money out of investor-state arbitration, and so you're clearly not going to endorse it. I mean, it's no different from what I've seen over the last 20 years in commercial mediation and getting outside lawyers to buy into the process. Clearly, I mean, lawyers, are in business. They're running a business, and there's an incentive if you are involved in investor-state arbitration. Clearly, that's the process that you understand, and you advise your clients on, and that's quite legitimate. The question is, to what extent then do you advise your clients or encourage your clients to utilize another mechanism, perhaps before that, like mediation to settle? Well, I think, just again, looking at the ICSID numbers, the number of cases that are withdrawn, clearly lawyers do become involved in settlement negotiations, and these matters are often settled even without mediation. So there obviously are a lot of lawyers in this field that also look to resolve the case short of going to arbitration. I've seen a sea change there too. I was in Montreal again about a year ago with Frau Konieczka of ICSID, and we were both addressing the similar type of room, and there was a lot of talk about how mediation could be utilized. So I think things have changed for outside lawyers too. They see this as a mechanism that they can also utilize. And as you know, yeah, I think the question about motivation is a good one. I think, you know, there is a whole practice area that can be developed around the mediation advocacy. And I think IMI has done a big job and a very good job in promoting mediation advocacy. And I think lawyers can recognize that there's a whole practice area there as well, which is another stream of revenue for them.
Absolutely. And not to throw it in there, but if anyone's interested, definitely have a look at the mediation advocacy standards on the IMI website. It can be really actually helpful to leverage when speaking with lawyers about these kinds of things. So we've got Daniel with another ripper of a question. He asks, do you have any experience in seeing states intimidating investors during a mediation settlement setting and insisting on their sovereign power? Is that behaviour common or something to be expected in investor-state mediation? And how do you think counsel for investors should prepare to deal with such behaviour?
Yeah, that's an excellent question. And the disparity between parties is often an issue in mediation, where you've got a more powerful party against a weaker party. And the mediator very much has to be aware of that. And you know, the key, and in all of our discussions about investor-state mediation, we've always said the key is really the process that is established before the mediation takes place. That's always important in every mediation, but particularly in investor-state mediations, where there will be a discussion that takes place between the parties to frame the process early on. And it's really the success in putting together the framework that will lead to a successful outcome in the mediation. And part of that will be discussing the representatives to come to the mediation and who they will be, and understanding that the state representative could very well be a minister, and you may then have, you know, the president of the company that is the investor there as well. There will clearly always be perhaps that in the background potential intimidation by the state, and it really depends on the circumstances of the case as well, where that could very well be a factor. I think some of the things that we've discussed is perhaps, you know, holding the mediation outside of the state, for example, in a neutral forum, trying to create an atmosphere where there's more of a balance between the parties. But that has to be recognized as one of the issues in this type of mediation. And I think planning for that and trying to develop a process where the parties are on a more balanced playing field will be an important aspect.
Great. Now, you mentioned costs earlier, and I think Calvin Hamilton's question speaks a little bit about this, because he says that third-party funding facilities and or security for costs are not readily available at mediation. Could these be disincentives for states to participate in a mediation?
Yeah, I think, you know, and Calvin, I think that's starting to change. I think there's maybe also a recognition by funders that maybe mediation is something that should be considered as part of the funding process, because it does lead to a resolution in any event, and that process, particularly if it's an investor-state process, could still be relatively costly. So it's something that, that certainly should be looked at by funders. And I think funders are another community that should be brought into this discussion so that they have an understanding for the process as well. But correct, I mean, that could be a disincentive for a state if the only way funding is going to be obtained is if there is actually an arbitral process. So that is to be considered, certainly.
Absolutely. I think we have time for one more. And so Brian has a question that just follows up on his earlier question. And so he's wondering if you can speak specifically to the case where a state refuses to abide by the settlement agreement and where it involves a specific performance obligation rather than monetary damages. Is it realistic for the investor to expect to be able to enforce, do you think?
Well, I mean, it's whether it's an arbitral award or it's a mediated settlement, if enforcement becomes an issue, then it's always going to be a problem. I think in a mediated settlement, it's much more likely that the state will actually comply with the settlement agreement, because they've actually negotiated that, and unless there's some political reason, and that may always, of course, occur in these types of situations, why they all of a sudden backtrack from the settlement agreement, it would be highly unlikely. Yeah, I mean, if it's a non-monetary aspect that has to be enforced, that becomes more difficult to enforce if the state doesn't actually wish to do so. And again, that may lead to another mediation in that circumstance.
Perfect. It sounds like another use for magic wands then, from the sounds of things. Great. Well, thank you so much to Wolf. I think this has been really fantastic. And I've already been receiving messages from people saying how much they've enjoyed this. So well done. It's been great. We will have the video of this presentation up in the next day or so on the IMI and SIMI websites. Thank you to everyone who attended and for your fantastic questions. It's been great having them here. But I think we can call it a day there. So thank you, and see you next time, everyone.
Very much.
Okay.
Thank you, Wolf. Thanks, everyone.
Bye-bye.